Hello, YouTube. I'm Vince White. I'm an employment attorney, and we're answering publicly posted questions from YouTube users who fulfilled the goal, the mission statement of this channel by posting their questions. And now we answer them, getting folks the answers they need from an employment attorney for free, which I think is special. All right, so this was posted on our video entitled "My Boss Perjured Himself, Lied Under Oath and Got Caught. How can I use this?" which was posted on August the 18th of 2022. And YouTube user Pamaroon posted this question about 2 days ago. And she posted, "Just a question, babes. Does it have the same effect if the employer lies in their answer to the complaint and in discovery, and it is then proven by audio evidence that what they said on the complaint contradicts their original statement? Also, would this be applied since it is not technically under oath?" Oh, would this still be applied since it's not technically under oath? The choppiness of me reading that question was all me, and I apologize. Okay, so I think what she's asking is essentially this. So the video that I made originally that she's posting on was about perjury, which is lying under oath, right? And I said a lot of things in that video. You may want to go watch that video. But the core of that video was a lie is an opportunity to a plaintiff. Like if the employer is lying, that is an opportunity for you to do a variety of things, like advance your case, impact the credibility of the employer's witnesses, make the judge, the jury, the finder of fact think poorly of the employer, the defendants here, right? So that's the core of that video. And I think what Pamaroon is asking is like, hey, what about a lie in the answer to your complaint, which is not necessarily a verified statement, right? They're gonna deny everything. They have to deny everything, and often they do lie in the complaint. And then she goes on to ask, and what about a lie in discovery? So I will actually break those two out. Almost every answer that's ever filed will contain lies. Almost every answer that is filed. If your case is legitimate, and then your employer does what they have to do in an answer, which is to say deny everything, you're a liar. This attorney's a liar. He's always up to no good, and this is all bullshit. That is essentially what an answer amounts to in a litigation. And it has to, because if they're not answering, this is all lies, then what they're actually saying is, okay, well, listen, some of these claims are valid against us. And they can't do that because if they do, the case is over, right? At least as to those claims. Judge says, okay, well, thank you for admitting to the claims, and we'll go ahead and start talking about damages on those claims, right? That's not what they're going to do. They're going to say, none of this ever happened. Often, that is a lie, right? So I'm going to differentiate out lies in the answer to the complaint, which are par for the course, to be expected. But now we come to lies in discovery. Lies in discovery can be used to impact the credibility of the employer. So I think in this hypothetical that you provided, the employer, their witnesses, they're telling lies in discovery, maybe at depositions, maybe under oath at deposition, right? Or maybe in interrogatories, maybe they're falsifying documents. I don't know the nature of the lie, right? But if you're able to then demonstrate the lie, you're having a real good day, right? If you've got yourself an audio recording that proves they lied, well, that witness is about sunk in terms of what I would believe from that witness, and I think most jurors feel the same way. So, absolutely, it is incredibly valuable. It's not under oath, but I will say that I don't think the average juror really cares about what isn't under oath, right? A lie is a lie is a lie. And the concept that lies under oath are a bigger deal than lies that are not under oath, kind of something only lawyers care about. And lawyers only care about it because they could lose their license, which is how they earn a living, right? But the average person running around telling lies under oath, generally, from what I see, the repercussions, the consequences are minimal if you ever see them at all. And so that's part of the problem, right? Is people are running around lying nonstop. Lay people don't really care or know anything about the difference between lying under oath versus lying when they're just walking around. To them, it's the same. To jurors, it's the same. And it's kind of a fiction that being under oath makes you more truthful. I don't think that's true. I mean, I'm not a psychologist, but if you came to me with data that reflected that people are more prone to lying under oath than otherwise, I would not be shocked. It's just, I think being under oath is a high stress environment. You know, people are watching. Maybe a full courtroom is watching. Maybe you're in a deposition. It's combative. Maybe you're being videotaped. Whatever it is, I think people are very, very prone to lying under oath. So I'm not worried about so much whether the lie was under oath or not under oath. I mean, listen, if they're lying under oath, I'm going to make a big deal out of that. I'm like, they perjured themselves. They're lying under oath. How you can't believe a thing they say, right? But at the end of the day, all the jury's really hearing is they lied, and we can prove it, right? Now, the other thing that's cool here, you mentioned audio evidence. Often, defense counsel is going to fight you in terms of playing that audio evidence. That's awesome, because if you can get that fool to fight you in open court, like if you can go ahead and start throwing in your audio evidence, trying to introduce it in open court where the jury can hear and know that you're trying to play a recording, and opposing counsel's leaping to his or her feet saying, whoa, 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 I object. What the jury really sees and hears right there is, you don't want me to see what really happened. You don't want me to see the best possible evidence ever that could exist, the recording of what actually happened. So instantly, that's almost more valuable than actually demonstrating that they lied with the audio recording, right? So yeah, 100% your perspective here. Lying in the answer, blasé. It's listen, you want to point that out. If there's a specific lie that you can prove, you certainly want to make hay on that. But lying in discovery, lying in depositions, that form of lie, way more valuable, major opportunity. Use that to your advantage. I hope this was helpful. If it was, like and subscribe. Helps me to help more people just like you.